It's impossible to be completely secure in this threat actor environment. I tell clients, it's not a matter of if, but usually a matter of when we'll have an incident, no matter if it's something minor or major. Defensible is essentially when you take a proactive approach to understand both the regulations and the related risk profile of your firm, and then develop a plan that is tailored to those functions. You need someone with the technical skill set to guide you through what are the cybersecurity risks, what are the data security risks, but you also need to have a regulatory expert guiding you on, well, what does a regulator expect? Have controls in place.
Welcome back to the Cybersecurity Cafe, where we talk about the place where cybersecurity meets the business, not the firewall, the boardroom. If you run an investment firm, a registered investment advisor, a private fund, a hedge fund, here's a shift that you need to understand. For years, information security sat in the IT column. Today, your examiner sees it as a control on insider trading. The line between who can access sensitive information and who could trade on it has effectively collapsed, and the firms that have not internalized that are the ones getting surprised by an exam. Our guest today has lived on both sides of that line. Anna Petrovich has spent more than 10 years at the SEC. She oversaw the complex financial instruments unit and led some of the landmark DeFi and crowdfunding enforcement cases. Today, she's Director of Financial Services Compliance and Regulation at Crowell, which means she now helps firms stay out of the exact situation she was helped investigating before. Anna, welcome to the show.
So much. I appreciate it.
So let's start with your story. You spent more than a decade at the SEC before moving to Crowell. What was the path that took you from enforcement to advising firms directly?
Sure. So I absolutely loved my time at the SEC. I learned a great deal, have a wonderful set of war stories at this point. But after 10 years, I really was looking to enhance my skill set and wanted to move into a place where I was in a less reactionary role and more of a proactive role. I wanted to help build something rather than when something fell apart. And so that led me to have a keen interest in compliance, and was fortunate to join Crowell and pursue that path.
That's right. I see similar parallels. We see a lot of the same in cybersecurity, where you go year after year and you end up doing these audits and you're breaking the same thing over and over again, and we're moving the ball forward, and it's like let me be part of the solution of solving that rather than the problem of just telling people what they're doing is wrong. So you oversaw some interesting cases along the way. What's the through line that connects the work that you did there, would you say?
So I would say that, fortunately, I have a broad set of cases that I worked on, and some of which are public, some of which are non-public, and had the good fortune of working in 3 different capacities. One was as a staff attorney, where I was the frontline person leading the investigation. Second set was more in a policy function, where I worked directly for the former co-directors of enforcement, and we got to see a window of all the cases that were coming through. And then the third set would be as a supervisor. But certainly, and I would say starting in year 5 at the SEC, cybersecurity, information security became something that we were looking at in some fashion, one way or another, whether it was the heart of the investigation or somewhat related to it.
Interesting. So, you sat in an examiner's chair, so I want to kind of pull on that thread a little bit. When an examiner walks into the room, what are they generally trying to figure out underneath all the document requests and the checklists?
Sure. So I think the good news is they're fairly transparent about what they're looking for. And what most of my clients want to hear is that once we help them develop a policy and they work with a provider such as yourself, right, that they're fine. But that's not where they stop, right? We're looking to see, do you understand the regulations that apply? But more importantly, do you understand your risk profile as a firm? And you don't get a pass for not being a cybersecurity expert. Most of those examiners are not cybersecurity experts, but they know enough to say, did you work with a partner who has that knowledge to do the mapping, to understand where the risks lie? And more importantly, do you have controls in place to address where you identify the risks? And finally, this is the one where the duties never stop is, are you testing the effectiveness of your program? Are you monitoring your own program? And so it's a really robust exercise when they're coming in.
So is that where the gap exists? Is that people think that it's a one and done thing and not an ongoing project or a program for themselves?
Absolutely. Absolutely. And I think there's sort of a default mindset of, well, I am by no means a cybersecurity expert, so how can the SEC expect me to know all of the details associated with the policy implementation? It's not the requirement, unfortunately. They need to be a partner and have insight into the process.
So does that mean a cybersecurity person or company or firm is requested to sit at the table with them during the examination, or are they typically taking a back seat?
So I would say that you're going to see both categories depending on where investigation is going. In many instances, the examiners do want to speak to the outsourced service provider because they're the ones positioned, right, to answer many of the technical questions that the staff may have. And it also allows them to test whether what the firm has been telling them is entirely true. We can appreciate it is very common for a CCO or a chief legal officer to assume the outsourced provider is doing much more than they actually.
Right. Yeah, I think where we've seen it kind of trip up, and where the expectation is that it's handled, where that does not necessarily mean that you still don't have to have oversight over that function, whether it's an internal person or an external person. You still have to have oversight over that function.
Absolutely. And I presume that an outsourced service provider, just like myself in consulting, I'm more helpful or knowledgeable than I am regarding climate, right? And so you can try to build the best defenses possible, but unless you really understand the firm's business profile and risk profile, you're not going to get the best service unless that partnership truly exists.
So what do you think is the most common misconception investment firms have in terms of how the SEC actually operates during an exam?
I think that, there's a couple of misconceptions, but I think one is that it's just a check the box exercise that the staff are right, that they are going to come in and say, okay, for Regulation SP, you now have a policy that says Regulation SP. You have now reached out to your vendors and sent them an email that says you will abide by a 72-hour notice required. The examiners are actually looking at it from a bigger picture, which is what risk mitigation controls do you have in place to protect your clients and investors, right? Because that's their mandate. And so they really want to see, has the firm taken a more holistic approach to cybersecurity, information security, and whatnot? So
at some point you crossed over from one side of the table to the other. What surprised you most about advising firms versus examining?
So I think I would say there's sort of two extremes that I noticed right away. One was, it was very humbling to see just really what were the operational challenges that firms face, right? I thought I knew when I was at the SEC, that it wasn't a perfect world. There were resources. But when I started helping firms, particularly those that are not the Metas of the world, Amazons of the world, JP Morgans of the world, they want to do the right thing, but they have finite resources. They have so many other regulatory requirements they're juggling at the same time. And so I think that was quite humbling, where I realized for them, it's a matter of just prioritizing risks, right? You can't sort of address every risk associated with cybersecurity. And I think that was really clear. The other extreme are the firms who are very overconfident in their programs, have very strong risk appetite, right? And so I have many clients who just, right, they're looking for that off-the-shelf policy, right? And look, someone from the outside to just take care of it and assuming that will be enough, right? And some of those leaders even make a business decision of, well, it's okay if we get a deficiency letter on this, right? Like, we're willing to assume this risk. But I think, from my perspective, especially on the enforcement side, working on pretty high profile cybersecurity matters, it's not just regulatory risks, it's reputational risks. And once investors and clients are involved in the problem, that becomes something that is really difficult to solve. And so sort of those two extremes that really surprise me.
You think it matters what the type of deficiency is, whether it's something where, okay, well, maybe they didn't do this particular activity, but that doesn't really impact me as a customer versus something that is putting the customer directly at risk? Something like along the lines of like last year, the big deal was mobile communication capture, very important for the SEC and clearly scared a lot of investment firms into now looking at doing that. But maybe the impact for the everyday client isn't as big as, say, something else like breach disclosures and things like that.
Absolutely. Absolutely. That certainly matters to them because now they're part of the story, right? Because, essentially, if you had a deficiency of, a problem that has not yet materialized into a tangible consequence, right? That's easier to, move on from than the situation of finding out that your personal data, your proprietary data is exposed, right? And there's been no sort of protections or minimal protections in place. It becomes quite personal, right? And it takes years to build up reputation and trust and just a moment to erode that. And so I typically try to highlight that side when guiding clients through the importance of this aspect of their program, that we have to look at it as both reputational and regulatory.
So when I started out doing what we're doing now 15, 20 years ago, since I started Triada, the distinction I always came across that compliance does not equal security. Like just because you're compliant doesn't mean that you're secure. But I've evolved that now to come back around where, yes, that's still the case, but the opposite is also not true. Being secure does not also mean that you're compliant. And that also delves into the idea of defensibility. You talk about the defensibleness of a firm. What's the difference between a firm being secure and a firm being defensible and in your eyes?
Sure. So I think that I've learned over the course of my career that it's impossible to be completely secure in this threat actor environment, right? I tell clients, it's not a matter of if, but usually a matter of when we'll have kind of incident, no matter if it's something minor or major. Defensible is essentially when you take a proactive approach to understand both the regulations and the related risk profile of your firm, and then develop a plan that is tailored to those functions, right? And so I view this as a collaborative exercise to build a defensive program. You need someone with the technical skill set to guide you through what are the cybersecurity risks, what are the data security risks, but you also need to have a regulatory expert guiding you on, well, what does a regulator expect? And you have controls in place. And, it's even more nuanced today in this world where many of our clients are operating on a global platform. So it's not just regulation ST for many SEC registrants that they have to be concerned about. There's state data privacy laws, right? There's EU laws at place. There's now an EU Act in place. So it is very, very complex. And even if they have the most robust cybersecurity controls in place, if you're not addressing each of those regulatory requirements, you may inadvertently find yourself in hot water.
Yeah, I would say that whenever we're dealing with even if you look at just the privacy laws and how companies have to agree, that's expanded globally. And that's complex enough for a company to deal with all the privacy laws. Now dealing with that on a regulatory basis for investments makes it that much more challenging. So talk to us through like what you're seeing now in terms of what regulators are coming. What are they most interested in today?
Sure. So I would say from the exam staff perspective, given that regulation ST is officially rolled out, they're looking to see have you taken steps to comply
regulation as key. And by that, I mean the manner that I was describing before, not just that you have a policy in place, but that you have taken that risk assessment approach to developing your compliance program. So that's item number one. The other piece of it is, remember, it's not just the exam staff, right? I come from the enforcement world, and what we're seeing under this administration is a proliferation of insider trading cases. And with those cases, SEC registrants need to recognize that they have a legal obligation by law, right, to establish controls to mitigate potential insider trading or misuse of material non-public information. And I think many firms overlook that component. And so truly those two oversight functions from the SEC are happening in parallel at this moment.
Is that the nexus for technology and cybersecurity as it relates to insider trading? Is that separation of or control around MPN?
Yes, right. So I think that most firms are viewing cybersecurity controls as a defensive tool, right? But you can use this as an offensive tool, right? Or additional support for your other regulatory obligations. You can oversee, right? Who has access to what data at your firm. You can implement monitoring tools, right, to notify you when certain activity is occurring. You can extract, right, searches, right? So one of my cybersecurity investigations, a key piece of evidence was an employee typing into Google, right, on their laptop, what is insider trading penalties or whatnot, right? And now AI tools were now the regulators are doing the same thing. They're getting the prompts, right? So why does officers can partner with these providers to use various tools to surveil and hopefully detect potential misconduct before the regulators?
Yeah, it's interesting. There was a case, I think, this past week, not related to investments, where I think a lawyer tried to erase their chat history, right? And then that became part of the investigation that was discoverable because of what he was putting into chat. Now, I think most firms today are not, say, archiving interactive chat like they are with email or mobile capture, but perhaps that's probably coming down the line as well, right? It is books and records potentially. So
100%. Like these AI tools are the new Google, right, of today. So I completely agree.
So if you're a lean firm and you don't have a giant compliance budget, where should most folks be spending their next dollar? What's the single highest leverage that they can take in there?
Sure. I would say the foundational point would be to have a risk assessment and related mitigation plan in place where the firm spends the resources to collaborate with partners that I talked about before. Do a mapping exercise to understand where their risks are and the correlated controls. They're not going to be able to invest in everything they probably want to. But if they have a thoughtful approach in where they devoted, right, which tools they've selected to invest in, that is very defensible, right? And so having that thoughtful exercise performed and documented is very, very critical.
Yeah, that's always a theme when it comes to compliance, right? It's not only doing it, but also documenting that what you've done properly.
And you don't have to do everything the same at the same time, right? Like I recently was coaching a client through doing a tabletop exercise, right? A very small firm. I said, well, maybe you do this every 2 years, right? And the other year, you're working through different form of testing, right? So you're rotating a type of surveillance and testing you're doing, so it's not so obvious, but you're having at least a plan in place.
Is the tabletops that you are they looking at it from purely a business operation point of view, or do you look at the almost like tabletopping the regulator coming in and doing an exam, or are you doing some combination of the two?
So would recommend doing a combination of the two. Certainly you do separately, however, right? So you can have that tabletop exercise from the cybersecurity standpoint, and then have a mock exam later to see, right, just how effective it would be from the examiner standpoint. The examiners are going to expect both, unfortunately. It's the price you pay for working in regulated industry.
So let's, I guess, touch on mock audits a little bit in that case. For the listener who's never been through one, what does a mock audit actually involve?
Sure. So you can really tailor it in terms of scope to the needs of your firm. That's good news number one, right? You don't have to have everything examined under the sun, but typically it would encompass receiving request lists, documentary information request lists, just like you would in a real exam. We support many clients through SEC exams. So we honor the exams and present them in the mock setting. And of course, and this is where I think the real gap comes, we have mock meetings, presentations, and interviews with our clients. And that's where really we see where implementation and how that is going is actually playing out in real life. And this is where we would call in even an outsourced provider together with our client as part of the interview to assess not only for program gap assessments, but also presentation to the staff, right? Are there to respond, right? And the tone and approach, all of the like. And then at the conclusion of this exercise, which usually lasts about 2 to 3 months, we would provide our set of recommendations, if any. And the good news is we recognize that you have a wish list, right? But also the importance of helping them understand where the greatest risks are. So we really strive to prioritize and risk rank our recommendations for our clients to say, okay, these top 3 things we recommend you do over this time period. Here are there 10 things that you think we should start thinking about, less critical, but if you have time, would be great to address.
Yeah, hit the low hanging fruit first, deal with that, then we deal with the rest. When you're going through this, and when you provide a client a mock audit report, does that ever get introduced as part of an examination? It's like, hey, we went through this. These are the gaps we found. This is our plan. We didn't get to it by the time you walked in the door, but this is what we're going forward with.
Yes, it will be in the request list number 1. Have you learned any mock exams? And the results and recorded those mock exams. Typically, depending on the firm, what I recommend in these cases is having an oral report at the end so that you can have a candid discussion. Right? We don't want to inadvertently create a roadmap for the staff, right? But it's also a good narrative to tell a staff that, hey, you performed this exercise, you go to these resources, you've identified it, and you've done something to address them. So this shouldn't hide the fact that they've had gaps, right? But being very thoughtful and how the output could impact them down the road is important. So it's something that our team is very trained, right? To the extent we do deliver written reports, we're very thoughtful in how we phrase our recommendations, right? They go through us. And in some cases, we're hired through a counsel such that firms at least can preserve the argument of attorney privilege. Doesn't always work, but you can present the argument that it's privileged.
So what do they typically catch that their own internal reviews won't catch?
Yes. So I think it's just important to recognize the inherent risk of creating your own homework, right? And so I have the good fortune of working with wonderful clients who have amazing professional experience, but you just have that inherent bias and blunders on, right? And so typically I find that in the interview setting is where we tend to find the most relevant information. So recently I was conducting an SEC mock review where I asked the cybersecurity provider, outsourced provider, are there any services that you recommended to your client, but the client declined? And then everyone gets very uncomfortable, right? And then the next question I'll ask is, would you agree with me that the following practices are standard best industry practices? Phishing tests, vulnerability scans, tabletop exercises, and I go through the whole list, right? The cybersecurity provider inevitably says, yes, absolutely, absolutely. Do you know that your client only has signed up for 2 of these services? So would you agree with me that they're not in line with industry best practices, right? And so again, that would be the adversarial mock exam, type format. But I think it really showcases, right, the gaps in terms of what the provider is actually doing and what the client has asked the provider to do. In most cases, it's good faith, right, that they made a decision, didn't understand, right? The impact of the decision. I want to push it, doesn't want to be too salesy. And so it's effective to have a neutral third party come in and say, well, these are typical questions you get asked by a regulator. And if you're feeling uncomfortable right now, that's a sign that you probably need to take steps to enhance your program.
So it's interesting. Like, I know when we've run into that exact situation, we've seen where there are definitely gaps that they should complete in order to fill. But then there's extra things that they're doing because we recommended it and they agreed to, that are maybe not called out in a regulation. And I think sometimes that causes some confusion. It's like, all right, why are we doing this and not this, this and that? And so it becomes, it puts the provider certainly in a, like you said, an awkward position, especially if there's an examiner talking to them directly that says, hey, why aren't they doing this thing? Or why didn't you explain it to them? It's like, oh, well, we did, but they said no. Now you're being an adversary to your own customer. And that puts you in a tricky situation. It's good to have it happen in a mock so that they're ready for it. For sure.
Yeah, no, absolutely. And there's also good answers to this in some cases, right? Where the cybersecurity provider can say, well, given this and the resources and budget the client has for this, we decided to invest in A, B, and C over the rest because of the risk profile. So that not answer doesn't have to be to do all of those things. The answer is that you've thought about your risks and you've taken a risk-based approach to complying with the program. And I think, unfortunately, it's when firms have an incident, there's less forgiving staff, right? So they want to say, well, you put on notice that this is something to think about doing. You declined it and had to put this in. This could have been prevented. Right. So it's a really, really challenging area. I've had a ton of empathy. My clients making these very, very difficult decisions.
No, and those are exactly the things that where I'm thinking about. There's two very specific technologies that we implement for customers that it's nothing that's called out in any sort of regulatory capacity and would never come up in a mock audit or a regular audit unless they specifically saw what the cyber programming that included it in the cyber program. There's no other reason why it would come up. And if they didn't have it, it wouldn't necessarily cause any red flags. But based on what we've experienced, one big part of it is one of the biggest risks that we see with investment firms is wire fraud. And we have specific things. You have some processes in place. We have some specific things in place that help mitigate against business email compromise as the predecessor to wire fraud. And so that's not something that's called out in any way. And so we find that that's important to put in. And so we're excited about telling about that story, but it may not be. Maybe we did that, but we didn't do this other thing that down the line the client should have. So you go through mock audits, you have a plan, you're going through that. It sounds like, Crowell is a very large firm. You're not only doing this, you do a lot of other things as well. Does Crowell get involved in some of that remediation as well? Do you bring in other resources, other parts of the firm?
Absolutely. Yes. We're actually there to help with implementation plan. We also have a large cybersecurity practice where we could partner with them depending on what the client's needs are, but certainly helpful to have an implementation plan and execute, right? And again, the goal isn't to do everything, right? The client doesn't have to take all of Crowell's recommendations, but having a thoughtful approach is very useful. And I think, our value add is really just the SEC exam insights. This is what I do. Most of my day-to-day responsibilities are supporting clients through regulatory aid. Professionals don't see these questions being asked in multiple exams, right? And most doing this every 2 years, right? So I can fill that gap for them and say, you should think about doing this, and here's why, right? The last 3 exams, this came up, and this was the outcome. And so it's very collaborative approach.
One thing we only touched on briefly, and I'm curious because I don't think we have any regulatory case law yet necessarily dealing with AI, but what do you see is coming down the road in that area?
Yes, it's almost like you cannot go by any day without talking about AI. And I think what I saw initially a few years ago was an overall hesitation to even think about using AI. And now the script has flipped, and now everyone is racing to adopt it from a competitive standpoint. Along those lines, I'm seeing some firms using public versions of AI tools, non-enterprise versions of AI tools, not recognizing the risks, right? Interns, they use AI the way that we used to use Google, right? They're being trained at the outset that that is inappropriate, right? To put in firm proprietary information. And then most importantly, thinking about how vendors are using AI as well. This is something that is just starting to come up in conversations, but it's equally critical to understand how the vendors are using and storing your own data.
So it sounds like making sure that there's some sort of AI questions around when you're doing third-party risk has to be on your radar. What else do you think there'd be like one or two things that if somebody had to do this quarter, what would you tell them to do first?
I would tell them to do, if they haven't already, their risk assessment, right? That is truly collaborative. You have the technical input, regulatory input, and impasse input. Having that plan in place, super important. And then the second piece would be to scrub your disclosures. So CC is all about transparency, full and fair disclosure. The investigations I worked on at the SEC were predominantly around disclosure. Not the fact that an incident occurred, the fact that did they have appropriate governance and disclosure on the related risks. And what I see many firms are doing now is updating technologies, like AI technologies, and not updating their related disclosures to reflect that. So it's certainly saying, take a look at those again. They're not just boilerplate. Work with your information security provider to have one review as well, and make sure that you're being as transparent as possible about the general risks. Again, you don't want to give hackers a roadmap into your own risk stats of your program, but the SEC will expect you to at least disclose what tools you're using and the risks associated with those tools generally.
Well, Anna, I really appreciate this conversation. This was great. If a firm realizes it has some gaps where Crowell can come in and help them out or help them out during these situations, how should people reach out to you?
Sure. I certainly on LinkedIn, find my firm email on Crowell's website and would be delighted to support clients in tackling these very challenging issues.
Thank you again, Anna. I want to thank Anna Petrovich for taking some time out of her busy day and welcome everybody to like and subscribe to the Cybersecurity Cafe podcast. Really appreciate your time and thank you.
Thank you.